terrorist attorney Lee Gellert. Hi, Your Honor. Hi, court. Judge Hendricks, this is Lee Gellert. I'm a lawyer at the ACLU calling about an emergency in AARP versus Trump. The phone number is this. It's 7:30 p.m. tonight. We understand our clients at the Blue Bonnet Detention Center are being given orders to sign, alien enemy orders, and told they may be removed as soon as tonight or first thing in the morning. This is related to the Alien Enemies Act. We would like to talk to the judge immediately or have the judge issue an order to have them not removed. The judge's understanding today, in his opinion, was that the government's representations would keep the proposed class safe. It appears that they are being asked to sign papers for their immediate removal. Thank you again. The phone number, thank you. This should have been brought to the judge's attention, if at all, in company with the federal prosecutor, the government lawyers on the other side, not in a secret meeting with the judge. And what I'm curious about is this was only exposed because this ex parte communication was done with a Texas federal judge. What if this ex parte communication had been done with Boasberg or some other District of Columbia judge infected with TDS? Would they have filed this notice about the ex parte communication and shared the transcript of the communication? Or would they have kept it secret? And how many of these other lawfare cases are the governments, are the lawyers working for the terrorists engaged in ex parte secret communication and coordination with these judges? Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you. Now, this is the case where the Tren de Aragua terrorists had first been in the court of Jeb Boasberg in the District of Columbia, even though they were physically present in Texas. They had been arrested, 5 of them. They had been put on a plane to Venezuela. And then somehow their lawyers got word that they were on the plane. And instead they got taken off the plane and put into a detention center in Texas. And they demanded habeas to be presented before a judge so the government could be compelled to explain why they were being held, why their detention was lawful. But of course, if they're presented in front of a Texas judge for habeas, they might get a different kind of hearing than they would if they were presented in front of a District of Columbia federal judge like Boasberg. And the lawyers ran to Boasberg. And Boasberg informed them, well, if this is a habeas hearing, I really have to send you back to Texas. So let's make up some other reasons why you can be here, why you could lawfully be in my court, where I could fabricate a claim of jurisdiction over your cases. Even better, I'll fabricate a class of every TDA member in America and pretend they're all legally in my courtroom, that I have legal authority over all of them, and I will issue a temporary restraining order this very day, without hearing from the government, preventing the government from deporting any TDA members under the Alien Enemies Act proclamation issued by President Trump. Ultimately, this got to the Supreme Court. The Supreme Court said, Boasberg, you dummy, you don't have jurisdiction. You have no authority over any of these people. And so a couple of them opted to go back to Texas and pursue their habeas rights in Texas, as they should have done in the first place. Well, they got in front of this Texas judge. And then last week, or now at this point, maybe a couple of weeks ago, these things go so fast, a couple of them ran to the judge and said, Your Honor, we hear. They made this ex parte phone call to the judge without notifying the government. We hear our clients may be deported again. You have to do something to stop it. And then the judge said, well, I'm not doing anything at the moment. We have the normal habeas process to go through. And on Friday, they called the judge again. They said, Your Honor, we hear they're being put on buses. We'll never be able to recover our clients again. There was no evidence of this. But they left that message with the judge. And then after a mere 42 minutes, when they didn't hear back from the judge in a satisfactory manner, they immediately filed an appeal with the judge's bosses, the Court of Appeals. And when they didn't hear from the Court of Appeals in a sufficiently timely manner, they immediately filed with the Supreme Court of the United States and got that famous 1 a.m. injunction from the Supreme Court, 7-2, in which Alito and Thomas filed their dissent later on Saturday morning. And of course, the White House then filed a response, and I've covered all that previously. These are the same TDA people. Now, prior to the appeal to the Court of Appeals and the appeal to the Supreme Court, they had reached out to the judge ex parte, meaning outside the normal courtroom environment and without notice to the government. This Texas judge said, hey, this is sufficiently serious that I need to document this, because this is not how communications with a judge is supposed to be done. This is the judge's motion he filed to document the inappropriate communications from the terrorist for the lawyers. United States District Court, Northern District of Texas, Abilene Division, different than the District of Columbia Circuit. As this court has mentioned in the courtroom, it received an ex parte, outside the courtroom, communication from an attorney representing the terrorist, the Tren de Aragua terrorist, on April 17th, 2025. So April 17th was a Thursday. This is the day before they came back on Friday with their panicked claim that their clients, their terrorist clients, were being put on a bus. That led to their Friday evening motion to the Court of Appeals and then immediately to the Supreme Court, and the Saturday 1 a.m. order, one paragraph order from the Supreme Court saying, we're going to put a stay on everything. We're going to pause everything for the Easter weekend, which of course other judges have now taken and run with. The weak Supreme Court gives these corrupt judges an inch, and of course they take a mile. That's in the nature of a corrupt judge. Judge Hendricks continues, consistent with the Code of Conduct for federal judges, I think it's actually called the Code of Conduct for United States judges, but whatever, and the relevant case law regarding ex parte communications, the court enters this order to provide all parties with the contents of the ex parte communication that the court received. Should any of the parties believe that a response is necessary, they may move for leave to respond. In other words, if the government wants to claim some damage here, something that needs to be done as a result of this ex parte communication by the terrorist lawyers. Substantive ex parte communications with the court are prohibited. You're not allowed to communicate with the court on the side without the other party present. At least not substantive communications. If you're arriving at court and you're in a car accident and you're going to be late, you can call the court, let them know you're going to be late. That has nothing substantive to do with the merits of the case. But any substantive communication with the court outside the hearing of the other party is prohibited for obvious reasons. No party to litigation would want the other party secretly communicating with the judge. Why? Ex parte communications may be fraught with peril, and judges must take great care with respect to ex parte communications, even in the most exigent of circumstances. Here we go. Here he gets it right. The Code of Conduct for United States judges explains that judges should not permit or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the presence of the parties or their lawyers, particularly the other parties. Even when circumstances may require such communications, the canon, the ethical code for federal judges, limits such communications to situations where the ex parte communication does not address substantive matters, and the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. The ex parte communication here from terrorist attorney Lee Gellert, counsel for the terrorist, does not meet this narrow exception. The voicemail addresses substantive matters, with Mr. Gellert informing the court that his clients at the Blue Bonnet Detention Center, what a pretty name for a detention center, the Blue Bonnet Detention Center, are being given orders to sign alien enemy orders and told they may be removed as soon as tonight or first thing in the morning, and that this is related to the Alien Enemies Act. Mr. Gellert, the terrorist attorney, further stated it appears his clients are being asked to sign papers for their immediate removal. Mr. Gellert also asked to talk to the judge immediately or have the judge issue an order to have his clients not removed, an injunction. These communications go directly to the substance of petitioners, the terrorist, first motion for a TRO, temporary restraining order. In discussing substantive matters, seeking to talk to the court immediately and alternatively seeking to have the judge issue such an order, the court believes that Mr. Gellert could have gained a substantive advantage in the proceedings by obtaining a TRO and a procedural and tactical advantage by making the request off the record, ex parte, and in the evening. Mr. Gellert left this voicemail even though the court earlier ordered the petitioners to explain why they should not be required to provide notice to the court based on the exception laid out in the federal rules of civil procedure or otherwise provide notice to the government. The terrorist lawyers did not file a supplemental brief explaining why the Rule 65B exception applied, and instead provided notice to acting U.S. Attorney for the Northern District of Texas, Chad Meacham. That's a Texas name, if I've ever heard one, Chad Meacham. Judge Hendricks thus notes that the petitioners, the terrorist lawyers, had not established prior to the voicemail any reason to believe that ex parte communications of any kind were appropriate. In light of the rules governing ex parte communications and the substance of the voicemail, the court notes for the record that it will not permit or consider the voicemail. The Code of Conduct for federal judges further instructs the judges that if a judge receives an unauthorized ex parte communication bearing on the substance of the case, the judge should promptly notify the parties of the subject matter of the communication, opposing parties, and allow the opposing parties an opportunity to respond. The court therefore enters this order notifying the government of the contents of this voicemail. The court did not return Mr. Gellert's phone call and did not otherwise have any ex parte communications with the petitioners or their counsel. Attached to this order is a transcript of the voicemail, and that's what we'll look at right now. The transcript of the voicemail. Terrorist attorney Lee Gellert. Hi, Your Honor. Hi, court. Judge Hendricks, this is Lee Gellert. I'm a lawyer at the ACLU calling about an emergency in AARP versus Trump. The phone number is this. It's 7:30 p.m. tonight. We understand our clients at the Blue Bonnet Detention Center are being given orders to sign, alien enemy orders, and told they may be removed as soon as tonight or first thing in the morning. This is related to the Alien Enemies Act. We would like to talk to the judge immediately or have the judge issue an order to have them not removed. The judge's understanding today, in his opinion, was that the government's representations would keep the proposed class safe. It appears that they are being asked to sign papers for their immediate removal. Thank you again. The phone number. Thank you. This should have been brought to the judge's attention, if at all, in company with the federal prosecutor, the government lawyers on the other side, not in a secret meeting with the judge. And what I'm curious about is this was only exposed because this ex parte communication was done with a Texas federal judge. What if this ex parte communication had been done with Boasberg or some other District of Columbia judge infected with TDS? Would they have filed this notice about the ex parte communication and shared the transcript of the communication? Or would they have kept it secret? And how many of these other lawfare cases are the governments, are the lawyers working for the terrorists engaged in ex parte secret communication and coordination with these judges? It's weird how Boasberg had 5 of these TDA guys unlawfully, without jurisdiction, in his court before Trump had even published the proclamation under the Alien Enemies Act. How did that happen? Was there secret coordination here? Is there secret coordination between all these NGOs, these anti-American pro-bureaucrat NGOs, undermining the political agenda of our elected Article 2 executive branch Trump, secretly communicating between lawyer and judges to foil the political will of the American people? Is this happening hundreds of times a day in the federal courts, but with federal judges that it's fine? They're the good guys. They're on my side. They're my tribe. We're all fighting Trump together. A little ex parte communication is not that big a deal. Nobody needs to know. I would bet good money that's exactly what's happening in these lawfare cases. Unlawful coordination between the anti-Trump lawfare attorneys and the TDS-infected Trump judges, anti-Trump judges. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.